After weeks of waiting, NASCAR fires back at the lawsuit. Yo, what's up everyone? My name is Jet. Welcome back to an episode of Inside Lines. Hope we're having a wonderful Thursday. As we get ready to begin the round of 8, we have to first talk about NASCAR's reaction to the lawsuit that was set by 2311 Racing and Front Row Motorsports. Now, they set this a few weeks back, a couple weeks ago, I should say, around the beginning of the round of 12, I believe. Well, finally, NASCAR has responded to this lawsuit. Now we're going to do a full breakdown. So this is going to be another long video. So hang tight. We're going to try and explain everything that's going on in NASCAR's filing response. Now, if you want to read the full response for yourself, I'll leave a link in the description box down below. Let's not waste any time and jump right into this. So like 2311 Racing and Front Row Motorsports, when they had their joint lawsuit, when they sent it out to the public, they had a pretty damning introduction. Well, NASCAR responded back with a damning introduction of their own. They say that plaintiffs, meaning 2311 Racing and Front Row Motorsports, have filed a meritless suit against NASCAR alleging baseless antitrust claims in order to obtain commercial agreements they previously rejected and to attempt to extort more favorable contract terms. Plaintiffs' overreaching requests belie their true aim, to use the antitrust discovery process as a weapon. Reasonable list and the totality of the circumstances confirm that the motion should not be granted. Basically, when NASCAR is saying that their claims that 2311 and Front Row are suggesting or claiming in this lawsuit, they're baseless, not true, or overreacting, and that this lawsuit should not move forward to trial in front of a jury. Now, NASCAR then later on, pretty early in this response, basically said that they're going to move forward without 2311 and Front Row in terms of the new charter agreement. The deadline for the plaintiffs to sign the 2025 charter agreements expired weeks ago, and NASCAR has taken steps consistent with its contractual obligations to other charter teams to plan for a season with only 32 chargers. Plaintiffs do not need these charter agreements to race, and indeed have stated publicly that they will be racing in NASCAR regardless. Now, the reason why 32, it's important to note that Front Row Motorsports, they have purchased a third charter, but they're waiting to be approved by NASCAR. Same thing with 2311 Racing. They have also been in agreements to purchase a third charter, I believe from Stewart-Haas Racing for 2025. But again, NASCAR has to approve that. Well, with them not being in the new charter agreement, it's interesting where these charters will go. Well, now we know that it will be reduced from 36 to 34. Basically, the two confirmed charters from 2311 Racing and Front Row, so the 34 and the 38 for Front Row, the 23 and the 45 from 2311, will not be in this new charter agreement. They will instead just give out these charters to the 32 teams that had signed the 2025 agreement. The idea that plaintiffs would race without a charter is not new or unprecedented. In fact, both Front Row and 2311 ran so-called open cars in addition to their charter cars in the 2023 Daytona 500, finishing 13th and 11th places respectively. As defendants' forthcoming opposition to plaintiffs' motion for a preliminary injunction will make clear, the court should deny the request's injunctive relief. So yeah, like I said earlier, NASCAR really does not want this to go to trial. They want this, to this lawsuit to be denied by a judge. However, NASCAR's reasoning is for this is a bit interesting. They say that, listen, it's unprecedented that 2311 and Front Row, they have actually raced with an open car before in the past. However, there is a big difference racing a car for a race and having two open cars for a full season. You have to approach that in two completely different manners. So it is interesting NASCAR's wording in this response. I say, hey, listen, they don't need to be charters. They can race open. It's like, yeah, they race open for one event, not 38 if you're including the Clash and the All-Star race. Anyways, NASCAR continues on by saying, quote, that the plaintiff's instant motion is not narrowly tailored to obtain relevant information regarding the release provisions, but instead seeks, quote, all documents regarding 7 topics from 6 NASCAR executives, including the president, CEO, and COO. for a period spanning nearly 9 years, as well as all contracts with speedways during the same time frame, and incredibly, plaintiff's motion asked this court to order defendants to satisfy the sweeping request within only 5 business days. Now that is something we have referenced in the first lawsuit when we talked about that 2311 and front row filed to the court, is that they basically want NASCAR to open their books. And with NASCAR being a private company, and when you have seen how NASCAR has evolved over the years behind the scenes, over the decades behind the scenes, Slap Shoes posted a good video, really good video, talking about NASCAR's grow to power, to real power, really behind the scenes. They've done it slowly and methodically. So 2011 Racing and Front Row wanting NASCAR to open their books over a 9-year period that does go back to the previous CEO, that being Brian France, and previous COOs of the companies and presidents of the company, very revealing that NASCAR does not want this at all. I don't think they so much worry about it going to court or going to in front of a jury. I think they worry so much about having their books open, because you will notice that if you read the full lawsuit, or the full response I should say, they do mention a good amount on how, like, hey, listen, we don't want to, we can't, this is not fair, this is not right, this is like, it's unreasonable. If you read the full lawsuit, you will hear NASCAR kind of state a lot about how they really do not want their books to be open. Another thing that you'll see NASCAR reference a lot if you read through this filing response is them reference section 10.3. Now, section 10.3 was, as Denny Hamlin described it, as the straw that broke the camel's back. That basically says that if you sign the 2025 charter agreement, that basically you lose the right to be able to sue NASCAR for anything revolving antitrust claims or anything that they've done that you believe was wrongdoing. Basically, you can't sue NASCAR for how they've process or negotiate this whole contractual negotiations with the charter agreement for 2025. Quote, the plaintiff's motion for a preliminary injunction focuses on one specific provision in the charter agreements, section 10.3, which provides NASCAR with releases from charter teams. Plaintiffs do not mention that section 10.4, on the other hand, provides charter teams with a reciprocal release. Now, if you look back at the original lawsuit, it does say, we're going to go over it, that the 2025 charter agreement also includes an anti-competitive release provision that purports to require the signing team to release any legal claims it may have against NASCAR that are connected to NASCAR's determination of whether and on what criteria to enter a charter agreement. Despite the representations to the court in their motion, section 10.3 of the 2025 charter agreements was not one of those stated concerns. In fact, in the 2.5 years of negotiation, NASCAR does not believe that section 10.3 was ever raised as a concern by either plaintiff, charter members, or their attorneys. Tellingly, section 10.3 is nowhere mentioned in the long correspondence sent by plaintiffs to NASCAR just a month ago. Now, let's back up a little bit. So yes, in the original lawsuit, it does not say anything about section 10.4, which NASCAR is saying includes a reciprocal release. Basically, what a reciprocal release is that it basically releases both parties of any claims in form of antitrust or anything like that. Basically, y'all can't sue each other. So it's like the teams can't sue NASCAR, but also NASCAR can't sue the teams. That's basically what a reciprocal release is. And the part about section 10.3 not being mentioned as a complaint from the original lawsuit, that is kind of true. Like, if you actually read the whole lawsuit, it's not stated in the original, like in the long explanation of everything, but it does mention it at the very end in terms of the relief part of the lawsuit. That the court grants plaintiff's forthcoming motion for a preliminary injunction enjoining defendants from enforcing the release in section 10.3 of the 2025 charter agreement for the duration of this action, and ordering defendants to permit plaintiffs to sign such a renewed 2025 charter agreement without being subject to any claim release of antitrust claims, so that plaintiffs may proceed with this action and obtain relief to which they are entitled under the antitrust laws while continuing to compete as charter teams in the relevant market. And section D, that the court declared that the release set forth in section 10.3 of the 2016 charter agreement is invalid as a matter of law to the extent it might apply to plaintiffs' antitrust claims in this action. So again, it's not stated in the whole meat part of the complaints that 2311 and Front Row sent to the judge or sent to court, but it is mentioned in the prayer of relief part. So that's at the end. Basically, the prayer of relief part is basically the section that the complaint wants changed or wants to be fixed to the defendant. Now, another interesting note to point out is that NASCAR says that section 10.3, was in the 2016 charter agreement and had not been touched in the 2025 charter agreement. That's not something that Denny Hamlin said, which he said on Actions Detrimental was something that NASCAR put at the 12th hour.
Point, when NASCAR put that clause in the very, I'm not speaking out of turn here because I know all these things are now public now. They put in there at the last, in the 12th hour of the agreement, they put in there, you may not sue us. If you sign this, you cannot sue us for anything basically that we have done through this process. You can't sue us for antitrust, can't sue it. So they took away all of our rights. All of our rights. So at that point we said, hold on, stop. We can't sign this because we know this is wrong. But if we do, we release them of any wrongdoing, and they've had wrongdoings.
Clearly, we have two sides saying two completely different things. NASCAR is saying that whole antitrust thing was in the 2016 agreement already, hadn't been changed. Denny Hamlin saying that, no, it was not in there. You all put that in at the last second. So really, the only thing that will settle this is if we got the 2016 agreement, which is something that we don't have at the moment. Later on in the response, NASCAR states that they will carry contractual obligations to the 13 teams that accepted its offer of 2025 charters, and consistent with the terms of the 2025 charters, NASCAR is working on reallocating funds that plaintiffs would have received to increase prize money and other special awards for the 2025 season for the benefit of teams that timely executed the charters for next year, as well as open teams who can't compete to win with the increased prize money and other special awards. So that is something that the teams of 2311 and Front Row, what they wanted was that, let's go through this lawsuit. We're going to go through this, but we want so that we can still be a part of the 2025 charter agreement, but not have to abide to the rules of, not allowing to have this lawsuit go through. Because if they had signed the 2025 charter agreement, they would not be able to go through with this lawsuit. So what the two teams are trying to say is that, yes, you want to pursue with this lawsuit still. We want to go through with this to court to try and everything like that, but we still want to be a part of next year's agreement while this case is going on. Well, NASCAR is saying, yeah, no, you missed it. You missed the deadline. We're taking that money that y'all would have gotten and spreading out to the 13 teams that did sign it. So that basically those 13 teams, or 90% of the Cup team field that did sign next year's agreement, they're going to get a pretty big bump in their pay raise. Now, one thing that NASCAR is arguing is that 2311 and Front Row are saying that this is unfair, monopoly, antitrust, all this stuff. But NASCAR is saying, you say all that stuff. You say that it's a detriment to the sport and all that, but yet you're trying to get more charters. Despite plaintiffs' allegations that the charter agreement are anti-competitive and that they will not be able to compete as charter members in the 2025 season at all, Front Row and 2311 each entered into agreements to acquire other teams' charters, subject to NASCAR's approval of such transfers. Now, that is a good argument, to say that why would you say that's anti-competitive, things like that, yet you're then trying to buy charters. And I think I look back at what Denny Hamlin said is that they want to invest in the sport. They care about the sport. They want to help the sport grow, which is why they're willing to play in this ballpark. But at the same time, they also understand that, listen, we want this to continue on, but we also understand that there needs to be a better way on how we conduct this, on how this entire business model is done. It needs to be revamped, just completely reset. There needs to be a better way. We will buy into this. We like the charter agreement. We want to be able to expand through this charter system, but how it's being oversought by NASCAR needs to be changed completely. But again, this is something that NASCAR has something on 2311 and Front Row is that, listen, you can't say all this and then continue to be a part of the system. So I can understand both sides with this argument. Accordingly, plaintiffs also asked the court to 1. Require defendants to approve those charter transfers, and 2. Retroactively excise section or completely remove section 10.3 from those signed agreements. And again, plaintiffs seek to have this court eliminate section 10.3 while at the same time leaving in place the reciprocal release the racing teams first obtained from NASCAR during the negotiations for the 2016 charter as set forth in section 10.4. So basically, again, what NASCAR is saying that the plaintiffs want section 10.3 removed. Basically, they want the notion that the teams can't sue NASCAR. They want that removed, but still keep the section that teams can sue NASCAR. Basically, they want a one-way system where we can sue NASCAR, the teams can sue NASCAR, but they can't sue us. That's what NASCAR is suggesting that the plaintiffs want. Plaintiffs cannot demonstrate reasonableness or good cause for the expansive discovery of the expedited basis that they seek. This discovery is unnecessary for the court to determine the merits of plaintiffs' motion for a preliminary injunction. Plaintiffs already have significant information about their allegations and contend that their motion for a preliminary injunction, quote-unquote, demonstrates plaintiffs' ability to show a likelihood of irreparable harm prior to having any access to expedited discovery. Alright, so what does that mean? That whole section means basically is that NASCAR is saying that for 2311 Racing and FRM Motorsports, they want NASCAR to really open everything about what goes on in their business. Well, NASCAR is saying that, listen, you already have what you need. You don't need any of this other stuff. There's no reason that you need any of this other stuff to help support your claim. You know, because what NASCAR is really referring to is that section 10.3, that antitrust claim that they're saying that, you know, that they put in there that the teams can't sue NASCAR for anything of that nature. They're really solely focusing on that. With the teams, specifically 2311 and Front Row, they're saying that, yeah, we want to look over that, but we also want to look over everything you've been doing these past, 9 or so years since this charter agreement has been put in place. We want to see everything. What NASCAR is saying is that you don't need to see everything. You don't need to see all the stuff that we've done. You can see, the stuff that's already public. That's all y'all need. You don't need any of this extra stuff that we have in the background. That's basically what NASCAR is saying. Anyways, we continue on. If the plaintiffs are correct, any early discovery that a party contends supports the ultimate merits of their case would constitute good cause. That is not the law. Plaintiffs have not identified, nor could they, any information that would be unavailable or subject to destruction in the absence of expedited production. Finally, the timing and procedural posture of this preliminary injunction motion makes expedited discovery unnecessary and inappropriate here. The timing part is another thing that we'll talk about later. Basically suggesting that NASCAR is saying that, hey, listen, you want us to do all this stuff in such a short amount of time is really impossible for us to even have a chance of defending our case. The timing of plaintiff's motion with respect to the date of the preliminary injunction briefing and hearing also favors against granting relief. Under the court's existing deadlines and hearing date, there is no reasonable way these materials could become part of the factual record before the preliminary injunction hearing. Plaintiffs rely in support of their motion for expedited discovery is due on October 23rd, and the preliminary injunction hearing is scheduled for October 4th. It would be unreasonable and unduly burdensome for defendants to collect, review, and produce all documents responsive to these requests for 6 custodians across a period of almost 9 years prior to the preliminary injunction hearing. Plaintiffs seeking all agreements between NASCAR and racetracks which quote-unquote contain exclusivity provisions or other terms restricting the ability of the racetracks to host non-NASCAR racing events since January 1st, 2016, which would require a review of hundreds of agreements and also likely implicates third-party rights such as confidentiality and notice. Even if it were possible to collect, review, and produce these documents within 5 business days, it is not, and the court granted plaintiffs' request on the same date that plaintiffs filed the reply in support of their motion to expedite discovery, defendants' discovery deadline would still fall on that day that plaintiffs rely in support of their motion for preliminary injunction is due. Plaintiffs would be unable to make use of the requested materials in that reply brief. So like I said earlier, when NASCAR is saying that, listen, you want all this stuff, all this information with NASCAR ISC, the previous history of not only the current CEO, Jim France, the previous CEO, Brian France, everything like that in 5 business days is, according to them, unfair as they do not have time to go over everything to properly, like I said earlier, to back up their defense. And it's understandable on one side. I do get that on one side. I'm not going to really comment on that because I don't know. I don't know if it's possible to get all this stuff in a short period of time. Usually, I do know in a company, usually you do have files that back up decades. You have files of everything that go back years and years and years. So again, I don't know if they're just saying that because they don't want to or if they really can, but I'm not going to really comment on that. Regardless, to basically sum up, NASCAR is desperately trying hard. And they do bring up some court case examples. If you want to go over the full lawsuit, again, in the description down below, they do go over some court case examples as to why that, hey, their situation is very similar to ours, and their situation had the outcome of it did not go forward to a jury into court, and it was dismissed by the judge. Why we should have that same result. So yeah, simply put, NASCAR really wants this case dismissed by Judge Whitney. They do not want this to go to trial because NASCAR, just from how they worded this filing response, and them mentioning Section 10.3 constantly, they mention other stuff, but again, you read through the lawsuit, they mention Section 10.3 a lot. And I think the reason why is because they know, they know that there is some form of wrongdoing there. Now, according to them, that it was in the 2016 charter agreement. Denny Hamlin saying it's not. Again, this is why I think we should go to trial to really see, okay, who is right? Is NASCAR right or 2311 Front Row right? Who is right in this situation? But I think overall, NASCAR desperately does not want this to go to trial. Simply put, as what the plaintiffs have stated, that if it does go to trial, they want to see their books. The CEO, COO, president, they want to see NASCAR's books, from ISC, when NASCAR acquired ISC in 2017, 2018. They want to see everything. And if you know NASCAR's history over the years, they've done some shady things in order for the executives to keep growing. The last thing that they want is their books open. If so, it's going to cause some major ramifications to how the people view NASCAR. Overall, that's it for this episode, going over NASCAR's filing response to the 2311 and Front Row lawsuit. Let me know what you think of everything in the comment section down below. Hopefully, I explained a little bit as to what NASCAR meant by this filing response. Hopefully, I laid out this lawsuit a bit easier for y'all. But again, let me know your thoughts in the comment section down below and what you think of this and what you think is going to happen. Do you think this case will actually go to trial, be in front of a jury, or do you think this is going to get dismissed by the judge? Let me know down below. As always, don't forget to leave a like and subscribe for more content. And until next time, my name is Jet from MDK. Thanks for watching.
You can't tell me now about time. Do you know how many lines I done put down, vibes I done sent out? But we ain't here to dig. I'll up the market till they come red carpet and kids. Success still the target. Soon I'll be crossing that bridge, but can't bring everybody with me. Family only. I got some people think I owe a favor, barely know me. That's why my focus on the road. It's all I know. I see them sticking close to play the